look at it as an entry because 58 is telling you to look at it. And all you do this time when you read 191, you're looking at the legislative competence only. And you just say there is law mentioned which could do this, and that solves the mystery.
That is what I've been trying, that is my submission.
Are you,
142
are you going in for the part relating to within the legislative competence of Majlis Shura,
Yes.
or relate to the federation? Which part?
The first part.
The first part.
Fine.
But the first part in itself doesn't give specific direction of competence kis cheez par hai. And as was said earlier,
Competition,
it says it
competence
would
in-
be anything and everything. So how do you say that from entry 58, matters which under the constitution are within the legislative competence? So then the question is, where under the constitution are you getting the competence from?
191.
191.
Then you're reading subject to the constitution.
So what is happening is, as I see it, is that you, as I said, from 142 you jump on to 58. 58 simply says, go back into the constitution and see if there is any legislative power.
Yes.
I come back to 191, but different, looking at 191 differently now. I just have to look at the competence, and I see that it says that there could be a law which could regulate practice and procedure. So that's, we just have to look at the subject matter. This time round, coming back after 58, we just look at the subject matter.
That is my reading. My lord, with regard to,
Mr. Zaid, you can always say, you don't have to agree with me. We are here to hear your contentions.
and I have respectfully
You can,
said it
I mean, are you being polite? You can say,
No, no.
don't need to agree with me.
I think it's fairly
But
clear.
Mr. Zayed, we have to
I've
understand,
only
we have
expressed-
to understand what you are saying.
Yes, yes, of course, and I've only
We
expressed
may
my
agree with you,
submission,
we may
of
not
course.
agree with you.
Of course, of course.
But
And
surely a judge sitting on a bench of the court is entitled, when a submission
And I
of high
appreciate those.
constitutional importance is made,
I appreciate those
to
observations.
appreciate that.
I appreciate
And I
those
think you
observations.
appeared me enough times to know that this is the way
I appreciate those observations.
that's the way I look
चलिए
at
आगे बढ़े,
things.
आगे next point
And
please
that's the way
चलें.
how.
Grateful.
that's
Zaid
the way
साहब
how-
आगे
I'm
बढ़िए
grateful,
please.
sir. The second point that I wish wanting to submit is that the right of appeal is nothing but extending the jurisdiction of the Supreme Court, which is provided under entry 55. And why do I say that? First, in relation to extending the power of the Supreme Court, the argument is that this can only be done where there is express authorization. And the counter argument is, where is the express authorization? There is none, and therefore this is a redundant provision. You can't read redundancy into a constitutional provision. So express authorization, I find it in a reading of Article 10A and 2A. And there is a judgment on this that I wish to cite, my lord.
No, just-
Here,
Just a minute. Express authorization under Article
10A,
10A
right to fair trial,
and Article 2A.
objective resolution.
No, and Article 2A.
Ji.
So is it your case, now these are, as the very appellations A indicate, that these were not there in the constitution as originally enacted. Entry 55 has never been touched. It remains as it is. So is it your case that prior to these articles being added to the constitution, the answer would go the other way?
My,
Let's look at the constitution on the commencing day.
sir,
If suppose on that day or the next day, Parliament had made this law with regard to the right of appeal, there was no 10A then, there was no 2A then, what
Sir-
would you say, what would the answer be?
my answer is, and the question I think is connected to the larger question that 185 में अपील जहाँ पे कॉन्स्टिट्यूशन ने प्रोवाइड करनी थी कॉन्स्टिट्यूएंट असेंबली ने वो कर दी अगर उन्होंने नहीं दी है 184(3) में टू बैड go back, make a constitutional amendment. That is the argument, right? My contention on that is that the parliament said, yes, हम 184 में अभी नहीं दे रहे, but हम ये power दे रहे हैं legislature को कि entry 55 में हम डाल रहे हैं कि you can extend your jurisdiction if at a later stage.
The word used is not extension. The word used
Extend.
is enlargement.
Enlarge the jurisdiction.
Now,
yes.
how do you interpret the word enlargement? As I see it, enlargement is of something which already exists. There is no appeal which exists. So how can it be enlarged?
Mr. Zahid, there could be two interpretations to that. I mean, my loud thinking that enlargement in this entry would have two sets. One is the existing jurisdiction being enlarged. The other is creating a totally new jurisdiction. Still, the Supreme Court's jurisdiction gets enlarged. So it doesn't really matter. The express provision is required for the existing provisions, but for a new jurisdiction, you don't need any.
And when you have two fair interpretations possible, which one do you go to? You go to the one
You see,
where the law will survive.
दो चीजें हैं ना, creating and in creating you are enlarging. Where is the power to create a new jurisdiction?
So that is where enlargement would come in. Most respectfully, sir.
Yeah, agar if we give enlargement a restrictive meaning, then can you give me an example when is it ever applicable then?
Sir, if I may
I mean, I can't think of a scenario, maybe you can help me think of a scenario. If we give it a restrictive meaning, the enlargement is different from creation of jurisdiction.
But
Then
also-
where will it come into play when, let's say this act did not exist and I asked you, please enlarge the Supreme Court's jurisdiction, what would you do?
It's a matter of semantics, you see. I mean, it's just a word in the sense that suppose if there is an appeal provided, would you not say that the jurisdiction of the Supreme Court stands enlarged? So it's just a word, I mean, and we've read the principles, widest possible interpretation. So
This
we
is
cannot be lost in the word.
Enlargement of jurisdiction can be read with Article 175(2) or not, because it is a case of jurisdiction. No court has any jurisdiction unless conferred by the Constitution, by or under the law. So if you read the enlargement, is it not the appellate forum is not an enlargement of jurisdiction to the original jurisdiction of Article 184(3)?
Indeed it is.
So it would be read with Article 175(2) or not, where the powers have been given.
Yes, certainly.
But the law,
My lord, what-
but the law over there would have to be a law that Parliament is capable of making, which brings us back to the same question.
What will go back to the same?
But you see, enlargement का तो example 185 में ही दिया हुआ है, और वो जो आपके वो थे ट्राइबल एरियाज की enlargement, वो एक्ट का नाम ही था enlargement of jurisdiction. लेकिन आपसे तो मैं सवाल कर रहा हूँ, उसका मुझे बताइए ना, आपने अभी 10A और 2A का जिक्र किया, तो आई एम गिविंग
और एक चीज और है इसमें जाहिद साहब, मिस्टर जाहिद
के अंदर
आप सुन लें, फिर मैं आपको एक और चीज उसी के
आप
जवाब
उसके
में बता
अंदर जो
दीजिए।
है एक बात आप कर रहे हैं कि जी पार्लियामेंट के पास शुरू से ही पावर था, उन्होंने कहा जब हमारी मर्जी होगी हम लॉ बना देंगे. इज दिस योर आर्ग्यूमेंट?
पार्लियामेंट ने उस वक्त
नहीं बनाया लॉ, ठीक है,
नहीं बनाया,
97
but ये
but you say that inherent in entry 55 is the power to create an appellate right of appeal in respect to 184(3). Is this your argument?
absolutely yes.
Okay.
My lord,
Now appeal, is it a procedural matter or is it a substantive right?
it's definitely a substantive right.
It is a
It is,
substantive.
yes.
Learned counsel.
So you
Learned
can create a substantive right by implication.
Not by implication. I'm
Learned
not
counsel.
creating it by implication. I am saying that the injunctions of Islam mandate that you cannot deny right of appeal.
Learned counsel.
And the Honorable Supreme Court of Pakistan says that this is what the injunctions of Islam say.
Which case is that? Which case is that?
Trying to get to that, PLD 1989 Supreme Court 6.
But the Honorable
Supreme Court, page 6.
Honorable Supreme Court also says that the lawmaker, if he intended the constitution makers or framers of the constitution, if they had intended to provide an appeal, they would have done so. And if they by intention did not do so, and 185 comes after 184, then be it so. I mean, if they did not provide an appeal and now the Constituent Assembly wants to provide an appeal, let it do so. But let it be by way of a constitutional amendment,
My
and
lord,
not by
another way of looking at
by stretching entry 55 out of shape.
My lord, another way of looking at it, if we look at 184(3), वो तो इस्तेमाल ही नहीं हो रहा था. Right? Later on, it started, and that is the reason that the parliament
कब इस्तेमाल होना शुरू हो गया? किस आप बताइए ना, जो इस्तेमाल नहीं हो रहा था, make your point.
I'm trying
तो चलिए आगे बढ़िए ना.
Senate Council.
जरा आप चलते रहे ना, थोड़े आर्ग्यूमेंट्स आपके हम नोट कर लें पहले. Zahid साहब प्लीज आर्ग्यूमेंट्स बताएं.
Zahid Saab,
If I may, this is
Zahid Saab, as I've understood your argument,
Welcome to the full court.
entry 55 is very crucial. It gives competence to the parliament in two ways. One is enlarging the jurisdiction. The jurisdiction which already exists, its enlargement of that. And secondly is to confer supplemental powers. That is in the context of the existing jurisdiction. So, any jurisdiction that exists that can be enlarged. It is not a creation of a new jurisdiction. And it is the existing jurisdiction which is being enlarged. It is unlike Article 185, where the original jurisdiction is of the high courts of other forums. It's only the appellate jurisdiction that has been created and vested in this court. Secondly, coming back to the question, why was there a need? If as interpreted by this court till 1988, if 184.3 had been exercised the powers the way that originally were intended by the framers of the constitution makers, there wouldn't have been a problem. The problem started after 2010, when everyone was speaking about it. The voices came from the lawyers, from everywhere, that the power was being abused, and we need to acknowledge that. So now, in that historical context, merely the jurisdiction has been enlarged.
Indeed, sir. In fact,
Well, the first case that happened under 184.3 was in 1976.
but the
और
floodgates
उसके बाद-
opened later.
उसके बाद 184.3 has been exercised, yes, progressively, but then the law developed.
Yes, of course it did. So, if I may just come to page 12.
That it-
इसके डोमेन से या कॉन्स्टिट्यूशन के डोमेन से बाहर होंगे तो स्ट्राइक डाउन होंगे. तो यहाँ तो ये जरा बता दें कि इंटेंशन वाज़ेह नहीं है दोनों आर्टिकल्स में.
Sir, इसमें मेरा humble submission will be that in this case, sir, still no rule can be made in violation of the constitutional
नहीं,
provision.
अब आप सवाल का जवाब या तो सवाल नहीं समझे, मैं आपके लिए आसान तरीके से बता देता हूँ. माय लॉर्ड पूछ रहे हैं आपसे
Yeah.
कि जहाँ तक जुडिशल कमीशन ऑफ पाकिस्तान का वहाँ ना सब्जेक्ट टू लॉ है ना सब्जेक्ट टू कॉन्स्टिट्यूशन है. इसका मतलब एक मतलब तो ये निकलता है कि ना कोई लॉ बन ही नहीं सकता है उसके मुतालिक, वो हमेशा कमीशन खुद ही बनाएगा अपने रूल्स. ये सिंपल रीडिंग है
जी.
और वहाँ 191 में सब्जेक्ट टू लॉ एंड कॉन्स्टिट्यूशन इसलिए लिख दिया गया कि आइन में भी हो सकता है और लॉ में भी हो सकता है. तो ये जमाल साहब की अंडरस्टैंडिंग गलत है, तो जरा समझा दीजिए.
नहीं, बिल्कुल सही. मैं जो अर्ज कर रहा हूँ कि जहाँ सब्जेक्ट टू यूज होता है वर्ड, वहाँ ऑलरेडी के कोई रूल इसके वायलेशन में नहीं बन सकता, which is already existing, subject to constitution, subject to law, already substantive law exist करता है. उसमें आपकी रेगुलेशन और प्रैक्टिस एंड प्रोसीजर पे आप नो फिर इसमें अगर नहीं यूज किया गया तो इसका मतलब ये इसको सब्जेक्ट ताबे नहीं किया जा रहा है.
ठीक है, ये आपका इंटरप्रिटेशन.
जी, इसको ताबे नहीं किया जा रहा है, but still no rule can be made in violation of the constitutional provision or any law.
ठीक.
जी.
Mr. Zubairi, is
Hello.
it so that it is the only Supreme Court which can make rules under Article 199? High Court and Federal Shariat Court, they are having the same powers?
The 202 of the Constitution gives the power to make rules to the High Court, sir.
And is there any law made for those two courts?
उनके अपना procedural laws हैं High Court में, and that judgment of a single bench judgment was cited by Mr. Bhandari on the last date, yearly 2021 Lahore, which deals with what is the meaning that rules can be made, but they are no, they have to be read with entry 55 does not apply to them, because that's why the rules of law reforms ordinance की बात की थी.
Parliament has put up clog on the Supreme Court. Why not on High Court and the Federal Shariat Court?
The High Court में है
What were those
202,
special
sir.
reasons to constitute this act?
Sir, 202 kindly be seen. Subject to constitution and law, a high court may make rules regulating the practice and procedure of court or of any court subordinate to it. So 202 is
203J is the
J.
Federal Share Court.
J. 203J.
नहीं, आप माय लॉर्ड का सवाल नहीं समझे। आपका पहले वाले सवाल का जवाब ये था क्योंकि रूल्स बन गए हैं तो अब सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ इज बीन रेंडर्ड इफेक्टिवली मीनिंगलेस। माय लॉर्ड का सवाल ये है, अगर आपकी ये बात सही है तो सुप्रीम हाई कोर्ट के कौन से रूल्स और फेडरल शरीयत कोर्ट के कौन से रूल्स बन गए थे, तो ये फिर इसका जवाब क्या होगा? ये मैं इसका जवाब आपने नहीं दिया।
सर पहले मैं आपकी बात का वो जवाब दे दूं।
मैंने सवाल नहीं पूछा, मैं सिर्फ आपको माय लॉर्ड का सवाल बता रहा हूं।
आपने कहा कि अब नहीं, मैं अभी भी कहता हूं आज आप रूल्स बनाने जाएं, they cannot be in violation of the constitution, subject, they have to be subject to any substantive law.
I can only use one word for it, profound.
जी, but still आपने ये कहा कि मैं कह रहा हूँ कि जी अब नहीं हो सकता। My lord, rule making power is a continuous power.
कि समझ गए ना, मगर माय लॉर्ड का जवाब नहीं दिया आपने।
जी मैं दे रहा हूँ उस पे सर, इसके अंदर भी जो लॉ उन्होंने बनाया है that has to be subject to constitution and the law, and that is the interpretation given in the judgment of.
इसके लिए तो कोई legislation नहीं हुई।
The Lahore High Court in a full bench judgment, जब ये क्वेश्चन अराइज हुआ था कि गवर्नमेंट ने भी लेजिस्लेशन कर दी थी और हाई कोर्ट ने रूल्स भी बना दिए थे, द हाई कोर्ट सेड यू कैन नॉट डू दैट। वंस द पावर वेस्ट्स इन द हाई कोर्ट, the government or the legislature cannot legislate in matters relating to rules because the rule making power exclusively vests in the high court.
जी so this is अगर judgment जिस पे आई PLD 2021 Lahore page 544 and relevant portion is para 61 page 580 onwards sir.
पढ़िए PLD दोबारा साइटेशन बताइए।
PLD 2021 Lahore page 544 my lord para 61
आपकी बुक में कौन सा हिस्सा है?
पेज 580 पेज 561
की बुकलेट में कौन सा है?
जी बुकलेट में नहीं है सर, मेरे नोट्स भी हैं, मैंने अपनी CMA भी दाखिल की हुई है, पर माय लॉर्ड ने पूछा तो इसलिए मैं निकाल के लाया हूं सर। पैरा 61 और बात 202 पहले कोट करते हैं और फिर आई विल रीड दिस पैराग्राफ सर।
ये पेज 544 आप कह रहे हैं?
580 सर, it starts at page 544 and relevant portion which my lord's observation is at page 580
सिंगल बेंच का जजमेंट है
जी।
Why you are citing it before full bench?
तो इसमें इंटरप्रेट हुआ है हाई कोर्ट की पावर्स के ऊपर जो 202 की पावर्स हैं
होगी
जी।
सिंगल बेंच का जजमेंट फुल कोर्ट को साइड फर्क पड़ता है क्यों नहीं पड़ता?
इसमें एक लॉ बना दिया था, अमेंडमेंट लॉ, और रूल्स में अमेंडमेंट कर दी थी। दैट वाज चैलेंज एंड दैट वाज सेट असाइड। काइंडली मे आई रीड विद लॉर्डशिप काइंड परमिशन?
You want to?
जी। Thus the High Court have been conferred the constitutional power regarding rules and procedure which may not only regulate the practice and procedure of a High Court but also any court subordinate to it. In exercise of this power, HC has made rules entitled High Court Rules and Orders, which contains elaborate procedure to be followed by the court subordinate to it in matters relating to adjudication of cases before civil court. Thus, not only has the High Court been delegated the power of making and amending rules in the first schedule by the court itself, but also by the Constitution by virtue of Article 202. The central question regarding power of High Court has escaped the attention of Government of Punjab while promulgating the amendment ordinance, which impinges upon the powers of Lahore High Court to enact and amend the rules. This proposition being stated for a simple reason that the amendments issued by amendment ordinance are made part of the substantive body of the court, not in the rules comprised of first schedule, and almost all of them relate to details of procedure to be followed by civil courts in adjudication of cases, which as numbered has traditionally been part of first schedule. A grossly egregious and anomalous situation has now been created with pits and the procedure introduced by amendment against the amendments made by Lahore High Court, which now run a parallel course. There are serious contradictions between the two processes, which is most cases are irreconciled. Although, I'm reading from the last line, although in such matters considered as is not normally assigned of, but in peculiar circumstances where across the board amendments in the rules have been made by committee of the High Court only a few months, Government of Punjab is obligated to have consulted LC for purpose of reconciliation. Also, while a reference to Article 202 of the Constitution has already been made, it also by implication follows that exercise of rule-making powers is constitutional which resides in the High Court. Therefore, if such power has already been exercised, emerges as an unwritten rule to be followed in all such matters that is of utmost important concern to be held and the government of province. It is not only essential but also to preserve the independence, so that is unique situation where judicial legislation is present. So this is the thing, once the constitutional power has been exercised by the court, because these rules made by this court have constitutional backing, this is what the judgments have said, it has constitutional backing. Even the rules under the Supreme Judicial Council, PLD 2021 Supreme Court page 1, page 94 says that though Supreme Judicial Council does not, the law does not permit, allows them to make rules, but they made the rules, Supreme Judicial Council, and those rules have constitutional status.
So take a look at Article 203E in
Ji.
relation to the Federal Sharia Court.
Ji.
Take a look at clause 2. Intra-court right of appeal in respect of judgment delivered by the Supreme Court under while hearing an appeal under Article 185. Would it be possible on your reading of entry 55?
No, that would go against the finality principle, because right of appeal against right of appeal.
इधर आप
But the logic is that here there is no appeal.
enlarge करके भी तो देखे ना, अगर ये section 5 जो है valid है, if it is intra vires, petition under 184(3) is filed, whatever happens, appeal is filed, whatever happens, there is a right of review against that.
Okay, so let me answer.
देखिए जो intra court appeal is original jurisdiction, never appellate jurisdiction. Intra court appeal, so there'll be two streams. One is the original jurisdiction of the Supreme Court. When a special single judge of the High Court passes an order, that is original jurisdiction of the High Court he is exercising, provided under intra court appeal. So that scenario may not be here at all, because 184, 185 is already there. We are only concerned with one kind of appeal, which is 184(3) appeal, nothing more.
No, I think
I understand your lordship's question, and let me answer it.
आप जितना broadly entry number 55 को पढ़ रहे हैं, तो उसकी implications है ना?
जी.
अगर उसकी implications fail कर जाती हैं, तो that's one thing. उसकी implications alive रहती हैं. तो इसलिए समझने की बात है ना. या तो आपका केस है कि जी appellate jurisdiction में नहीं हो सकता, further ये power खत्म हो गया, मुझे तो फिर नजर नहीं आता उसमें कोई ऐसी limit.
मैं ये नहीं कह रहा, मैं वाज़ेह तौर पे ये कह रहा हूँ कि जहाँ तक power of enlargement hai, that exists not just in relation to 184(3), it exists. And my answer is, the line that in the end there must be an end, unless the parliament says so. Unless the parliament says so. That is my...
You added words to my words.
Yes, indeed. I'm taking the liberty of adding the words, unless the parliament says so.
I may or may not agree with you.
Subject to your...
Grateful, sir. So, if I may move to the next point, this challenge has been dressed up as an issue of independence of judiciary. There is a plethora of case law which identifies that how important, crucial, critical independence of judiciary is to our system. In relation to what constitutes independence of judiciary, what are the things that make up independence of judiciary? My Lord, I will not make your lordships read, but I'll just cite the relevant paragraphs of a few judgments. My Lord, the first is the Sharaf Faridi case, PLD 1994, Supreme Court 105, at page 107.
Please repeat the citation.
My Lord, PLD 1994, Supreme Court 105,
At?
107.
Okay.
The second is PLD 2009, Supreme Court 879, the Sindh High Court Bar Association case, at page 1228, para 17. And lastly, PLD 2010, Supreme Court 61.
2010 Supreme Court?
Page 61. This is my Lord Chief Justice Iftikhar Muhammad Chaudhary versus President of Pakistan. And the relevant page is 173, para 157. My Lord, in relation to international treaties and covenants which also define what independence of judiciary is. I have taken the liberty in my concise statement in paragraph 10, I have drawn out what these international treaties say. I will just read one sentence from there, my lord. Independence of judiciary, according to the Council of Europe recommendations, says, the principle of independence of judiciary means independence of each individual judge should be able to act without any restriction, improper influence, pressure, threat, or interference, direct or indirect, from any authority, including authorities internal to the judiciary. This is the first definition of independence of judiciary that I was able to gather, which specifically says that from internally from the institution, there has to be independence. My lord, repeated questions have been raised, but no one has identified which fundamental right affects the petitioners. How independence of judiciary is diluted by this law. An argument is certainly made that in relation to even the practice and procedure of the Supreme Court, tomorrow the Parliament may make another law. My lord, when it makes another law, it will be tested whether they are interfering in the independence of judiciary. And it will be struck down if they do so, but not at present. This law does not. My lord, most humbly, under Article 184.3.
Zaid Ibrahim, how do you say that? Where the Act obligates the Chief Justice or the two other judges to act in a certain manner, and as was rightly pointed out by one of the councils, they are micromanaging or trying to micromanage or trying to interfere in the independence of the judiciary insofar as the Parliament will now dictate how benches are to be formed or how what cases are to be fixed by the committee or by the Chief Justice, and what would be the number of judges sitting on the benches, and how would the roster be made, and what sort of cases which go before what sort of benches. I mean, if this is not interference in the independence of the judiciary and micromanagement of the judiciary, I don't know what else would be.
My lord,
I think I think this is premised. I think we should also realize that this was premised on undermining the office of the Chief Justice. Now, if the office of the Chief Justice, at least I do not read it as the same as the judiciary. I think judiciary means everyone. Chief Justice is a person. So yes, it is premised, but if I use the term independence of judiciary by saying Chief Justice, then we should use the word independence of the Chief Justice and not use the word judiciary. And then the argument goes back and forth, the same one, he's the head of the institution, so he represents the judiciary. I'm not very convinced with it. So I would say, yes, it definitely undermines the independence, or whatever better word you want to say, use not the word independence, but some other word may be better, of the Chief Justice, but not as a judiciary as a whole.
Two very brief responses. Your Lordship should give credit when this law was being debated in Parliament. The very point that your Lordship has said was also raised. And they said...
in fact, incidentally, there are two orders of this court, and the learned Attorney General also undertook to place on record the debates,
in an earlier, my lord, in an earlier hearing, it was pointed out that it is available online.
If that order
I think it's been placed by
with,
one of the lawyers. It's available in CMA 8565. One day's debate
It's
has
a
been
good
placed.
150 pages.
Some parts of it have been placed
okay,
on the file.
All I was trying to point out that the questions that your Lordship has raised, the Parliament also grappled with it. And in my humble view, these matters, can't be looked in an isolation. Let's face it, I do not know how cases get fixed. I do not know how benches get constituted. I don't know how 184.3.1 case gets presented on the 12th of April and on the 13th of April it gets fixed.
So, Mr. Zahid Ibrahim,
This itself is a vindication of this law.
Can be fixed by the Supreme Court itself
So,
if you point
all
it out
the
to
Parliament
the
is saying,
Supreme Court
all the-
and the competent authority, which is the full court, which constituted, which promulgated the 1980 rules, they can revisit the rules and fix the issues.
Sir,
How does the Parliament come in?
Mr.
Order,
Zahid Ibrahim,
order 19 of the Supreme Court rules, Order 19 of the Supreme Court rules says that all appeals filed in the registry shall, as far as possible, be heard in the order in which they are set down.
Okay. So
Does it
it's a
happen?
question of
I mean-
implementation. So according to you, the rules are already there, they are not implemented.
No,
So if it is incorporated in a statute, it would ensure implementation.
It is not incorporated in the
Mr. Zahid
statute.
Ibrahim, there seems to be a great fear regarding open door syndrome thing that's going on. So in this case, what we have to identify is whether there is a door or not. So if there is a door, there could come a law which could strengthen us, which would strengthen the Supreme Court, enhance the independence of judiciary. I'm okay with that coming in the door. But if something else walks in the door which affects my jurisdiction, reduces my jurisdiction, violates fundamental rights, access to justice, independence, I strike it down. So what's the fear? What is this open door syndrome going on?
It's a red herring.
And again, Mr. Zahid
The
Ibrahim,
main question is.
Mr. Zahid
the main
Ibrahim,
question
all
here
that,
is
all
whether
that the
there is a
Parliament
door.
has done.
Yeah, door is the question that will determine.
The Constitution, for the
Zahid-
time being,
Zahid Ibrahim.
does not give a door to the executive or the legislature to interfere in the internal affairs of the Supreme Court.
So this bench has to determine whether it all is a door or not.
Mr.
What comes
Zahid
through the door
Ibrahim,
is not my problem.
I think these proceedings are a classic example of how the jurisdiction or the power was exercised by the Chief Justice. As I pointed out earlier, there are a lot more important cases which never get a turn. Now here, everyone is saying it's a good law, but everyone fears this open door syndrome, as my learned brother has stated. I view it differently. The Parliament, since this court having the power under Article 191, was even refusing to call a meeting of full court. And all that they did was to structure the discretion. They have not given any directions, and all that they have done is tried to structure the discretion which this court was refusing to do, and there were obvious abuses.
And the unstructured discretion, my lord, we can close our eyes, but the public confidence in the judiciary has eroded. And we are all invested in this.
I think, Mr. Ibrahim, if I may ask you a question, assuming that this law is, I'm looking at the practice and procedure bits of it now, assuming that this law is intra vires the Constitution, in light of this law, who is the master of the roster?
Well, according to one judgment,
No, I'm talking of the law. In light of this law, who is the master of the
I'm
roster?
not sure where the term even master of roster comes from.
Who decides which cases get fixed where, etc., etc.?
The committee decides. The committee.
No, you're wrong. Committee is the creature and creation of Parliament. At its broadest level, this law is a claim by Parliament that Parliament is the master of the roster. And I'm asking you a question. You don't have to, as already pointed out by the Honorable Chief Justice, you don't have to agree with the question. To me, this is the crucial aspect of this law. It is not whether the committee consists of 3 judges or 5 judges, or Parliament says let the full court do it, or let the Chief Justice do it. Those variations, as has been pointed out, you said it, maybe that those laws will be made, maybe they won't be made, that's speculative. Whether it is speculative or not, I put that to one side. The point is, and this is the question I'm putting to you,
Yes, ma'am.
that in any of those scenarios, including the one that we have before us today, it is not the committee that is the master of the roster, because the committee is a creature of Parliament's will. Parliament has willed it into existence. Therefore, it is Parliament that is the master of the roster. Now, placed at that level, seems to me that this is directly in conflict, directly contrary to the principle of independence of judiciary. What would you say to that?
Can the master
I
of the
would
roster,
say- I would-
Mr. Ibrahim, can the master of the roster speak? I would add the word the purported master of the roster. When I became Chief Justice, and I looked at it earlier also, the existing rules of the Supreme Court of 1980 stipulate simply that the Chief Justice will constitute benches. Now, practice had developed, maybe it's in accordance with the rules, I can't find it, that every week, list of cases prepared, a list would go to the Chief Justice, this case would go to that judge, and this case would go to that judge, and this case would go to that judge. I have discontinued that practice. This is not even the job of the Chief Justice. This is the job of the registrar. They can be given broad outlines, first in, first out being the general principle. Then there can be fast-track cases, election matters, naturally election matter will become redundant after a certain period of time, bail matters, etc. But to see even the cause list of the day and where it goes, I think, and this is the master of the roster speaking, please give me this power so I can use it from the existing Supreme Court rules. Where do I have this power? I can't seem to find it. Can you help me with that?
And Mr. Zaid Ibrahim, there are no masters anymore in the world, you see. If you look around...
He always wants to undermine my authority.
With respect to the
lighter
master.
note.
No,
So I don't see that as a
think
master.
the
So Mr.
question-
Zaid Ibrahim, what I want to say is that if you look at internationally, it's about time we wake up to the world, you see. We have US, UK, Germany, Brazil, Nepal, Philippines, just to name a few. There's no such thing as master of the roster. It's a collegial system that works, and that's across the board. And it's about time that we also woke up to all this, you see.
My lord,
With due respect to the master
with
here.
utmost respect, I say we need to wake up to what's outside this room.
You see if I may add to that,
And to answer-
under our system, and I don't mean to be disrespectful to anyone, masters come and masters go.
Yes.
This is not a lifetime appointment.
But while they are
One-
there-
No, just a minute. One Chief Justice may have one view of the matter, the other may have another view. And those who come, and I don't mean immediately, I'm not talking of potential Chief Justices sitting here, I'm talking even way into the future, they will do whatever they want to do. But that is not the important point. The ephemeral, fleeting, whether it's 1 year, 2 year, 3 year term of a Chief Justice, of a master, if you want to put it that way, in the more traditional sense, that is in a sense beside the point. The question is, within the framework of the Constitution, separation of powers, independence of judiciary, ultimately, who is the master of the roster? And can Parliament lay such a claim and not violate the Constitution? This is the ultimate question.
But if I could just
May
bring
I-
in another dimension to this, I don't know if you've looked at this new book called The Court on Trial, and they've done a data-based analysis of the Indian Supreme Court, where they say that invariably through data they've discovered that Chief Justice, if he has all the powers, he can manipulate cases. He can ensure a certain outcome. This is through data that they've presented. They've said that judges who have been dissenting, Subha Rao is one of the judges who dissented several times during his tenure as a judge, but as a Chief Justice he never dissented because they would manage the bench. So this has been through data now established that if one person could get a bench constituted, get the judges on that bench, he could ensure the outcome. Don't you think that sort of directly hits at the core of independence of judiciary?
Of course it does.
And
And let
again,
me,
Mr. Zaid Ibrahim.
I've also read the book that my learned colleague is talking about, and I look forward to having a very enjoyable discussion about it with him. But the thing is, if the principle, it's the principle that matters.
Yeah.
If one man can do it, maybe 3 persons can do it.
Your Lordship
Maybe
is,
5 persons can do it. No, if you don't like following logic to wherever it goes, then the logical answer is everything should go to the full court, but that's practically not possible.
Mr. Zaid
The
Ibrahim.
point is, the principle of the thing still stands. My question to you still stands.
I
Yes.
want to have
Please
the
answer
opportunity
that.
to answer it.
Respond करें उसमें.
The answer is in two. First, I would urge your lordships to not read this law as an encroachment into the independence of the judiciary. By no stretch of imagination is this. Even in Parliament when this was discussed, it was discussed that the bar has wanted to do this for a long time. PTI is challenging their legal counsel. Hamid Khan was cited in the debate as supporting this law. To answer your question, Parliament does not seek to be the master of roster of any.
Not a
in-
question of whether they seek to be this
Or they have
seek
not.
to- No,
Mr.
sir.
Zaid Ibrahim.
The principle that is being established is that they are. Whether they seek it or not is beside the point. This is
Mr.
the
Zaid
core
Ibrahim.
of the question.
I would
in-
say that it is
Ibrahim,
not.
in
And
most
secondly,
of,
secondly,
Mr.
in
Zaid
relation-
Ibrahim,
Just on the
Sir,
lighter
एक second,
in
note,
most of the jurisdictions,
the only
the
way I
fixation
cannot
of
read
cases-
into this is to keep my eyes closed.
No, is to not chase
Mr.
shadows.
Mr.
I would say
Zaid
not chase
Ibrahim.
shadows. And just one last thing. My lord, your lordship had said that, oh, chief justices are there for 1 year, 2 years, they go, new chief justices come and, there's no, it's not you're stuck for this forever. But my lord, what do we tell people who had
No,
homes
I
in Nasla
know, I
Tower?
think, no,
What do we
sorry,
tell
Mr.
people
Zaid,
who lost
Mr.
jobs,
Mr. Zaid
employment,
That is not an
lives,
answer.
property?
Mr. Zaid
There
Ibrahim.
should be a right of appeal.
ये देखिए, let this message not go out from this court that the constitution and the laws of Pakistan are dependent on who the Chief Justice of Pakistan is. This message must not go out from this court. The laws of the constitution and the laws of Pakistan are there, irrespective of the size of the Chief Justice's foot. So let this message not go out that the next Chief Justice can do as he pleases. Absolutely not. Let that be clear that what the law is, what the constitution is not a variable commodity subject to the whims and wishes of the Chief Justice of Pakistan. That must not be so. And if that is so, that is destructive of the constitution. It is destructive of the rule of law. It is destructive of the independence of the judiciary. It is destructive of everything. If we go that far and say, oh, let the next one come, he'll retire, 25th October, he goes, the next one will come, he'll do his own way. No, absolutely not. He should follow whatever is the proper method of doing things. It's not, sorry to say, if anybody thinks in that side, Parliament, or in any other situation that he becomes all powerful, I at least will not let this institution put forward this thing, if we will do as we please. When we do. Here we have autocrats writing books, friends not masters. We don't want to even say that. I am not anyone's master. I am servant to the constitution and an abd of the Almighty.
Mr.
That
Zaid.
is the place of a judge. It should remain there.
Mr.
It should
Zaid.
not be variable commodity. Oh, the next justice, how will he do it? So
Mr.
I don't. This is a
Zaid
very unhealthy sign if it is so variable. Then where the Supreme Court's change laws, a law is enacted today, the way it goes up interpreted by one court, by the other court, by the higher court, by the time it comes to the Supreme Court, takes about 20 years for any law to settle. Now, if it's such a variable commodity that we stump everything and we come 184.3, today the law of Pakistan is this.
Certainly, we look for consistency,
Mr.
and that's
Zaid
what
Ibrahim,
the legal
I
system
think,
should provide.
if I'm not wrong, in most of the jurisdictions, they have adopted objective criteria for fixation of cases and constitution of benches. And they have named it as the natural judge concept. And they have done away with the concept of master of the roster. It's done on an objective basis, laid down criteria, and not on the basis of a discretion vested in one person.
I think it's high time that we bury masters and bring in trustees.
Yes.
In fact, the constitution starts with that word. It's a sacred trust. Because you have mentioned Islam, but I was surprised nobody else is mentioning Islam. I mean, it's mentioned on the streets more than it is in the courts of law.
Most grateful, sir. Thank you for the opportunity.
Mr. Zaid,
Yes, sorry.
बड़ी इनके जो जितने भी मास्टर ऑफ रोस्टर्स प्रेजेंट और फ्यूचर के होंगे इनसे माजरत के साथ ये देखना है कि इस लॉ में आया ये बताया गया है कि कितने बेंचेस क्या बेंचेस किस तरह बनेंगे या कौन बनाएगा किस तरह बनने में और कौन बनाएगा में जरा फर्क होगा
वो आप लोग आपके ऊपर छोड़ा हुआ है जिस तरह आपने कहा कि जो अगले आने वाले हैं और जो है उन्होंने आप लोगों के ऊपर है ये पार्लियामेंट वहां पे नहीं फैसला होना है आप नहीं करना है ग्रेटफुल माय लॉर्ड मोस्ट ग्रेटफुल थैंक यू
शुक्र है यार
Who do you represent?
My Lord, I represent the PMLN 8301. My Lord, I'm sorry I made a mistake as some of the earlier comments. Apologize. I'll